Hello everyone, welcome back to another tutorial for Property B. Um, Today we're studying more exceptions into feasibility, riveting they are in Personam, Paramount Interests, and I've tacked on inconsistent legislation too. Um, uh, so the academic integrity statement, the Monash LSS strictly condemns academic misconduct and has a zero tolerance policy towards persons who are found to breach their academic integrity by misusing our educational services, could use with a comma. The Student Tutorials program is a purely supplementary resource aiming to provide extra assistance to students. Students should primarily engage with faculty-run seminars, workshops, and tutorials, as STP resources cannot be solely relied on for learning. While our LSS tutors work hard to deliver value, the unit content, reading guides, and the law can all change. Consequently, students must exercise their own discretion when using our resources. When there is an inconsistency, students must always refer to their chief examiner. Quickly, just like to thank our sponsors yet again. We've got Gilbert and Tobin, Cause Chambers Westgarth, Clayton Utes, and King and Wood Mallisons. And before getting into it, I'd like to pay my respects to the people of the Kulin Nation, on whose land I join online from today. And I pay my respects to their elders, past and present. Okay, first up in Personam. Um, I don't know if this is too conceptually difficult, but I think if you use examples, this one can become really quite easy. Um, Indefeasibility does not allow a registered proprietor to hide behind their registration to avoid the consequences of known legal and equitable causes of action against them created by their own conduct. And that principle comes from the all-knowing Privy Council in Fraser and Walker. Sounds like a convoluted sentence, but it's quite simple. Effectively, this is talking about causes of action which force someone off the register. And indefeasibility will not block claims which will force a proprietor off the register if their conduct has created that cause of action, the remedy of which will get them off the register. Um, so you have your typical example, and there'll be some more typical examples in the case, particularly Bar and Nicolay that we'll study next slide, I think it is. But say you have Y, who is the registered proprietor of Blackacre. He then enters into a contract of sale with B. Y, and that's specifically enforceable, let's say. Y later reneges on this agreement and he decides he wants to sell to someone else, a dog. Effectively, Y cannot stand on his status as registered proprietor to ignore the equitable interest he has created in B, being the equitable fee simple created from the contract of sale. And what this exception of in personam is saying that B can bring the action to get Y off the register. And how he'll do that is by bringing an action for breach of contract. And he'll sue for specific performance because land is oh so valuable and you can't get damages. You want specific performance. And what is specific performance of a contract of sale? From the seller's point of view, well, the buyer, it is to force the seller to transfer the property to you. So you can see how the remedy of this cause of action, the breach of contract claim, is getting the registered proprietor, that being Y, off the register, a forced transfer. So I think that helps to sort of crystallize what it is. All this is saying is that indefeasibility is not some sort of shield or a defense against causes of action created by the registered proprietor's conduct. What indefeasibility is it protects them from unknown, really, unknown or, well, not necessarily, well, it protects them from equitable interests that they have not created in the land. But if they create an equitable interest, they cannot avoid the consequences of having created it through their status as being registered proprietor. It sounds like, whoa, this is a big deal. It's pretty common sense, and you back in property A, you'll have studied contracts of sale, and you'll come across the order for specific performance. You'll dealt with it in equity, and you'll have probably dealt with it a bit in contract B too. So it's yeah, all it's saying is that it's not this shield against those sort of causes of action. They still exist, and if you didn't, well, half of our law degree would be redundant. So it's quite a good thing that Fraser and Walker said that sentence at the start. Before we get into the cases, some general points that for some reason they want you to know, and I think they want you to bring up in some cases. I think I did on my exam. Um, and I mean, I don't know what mark well, I don't know like where I lost my marks or got my marks, but presumably I was paid out for it. Um, Forgery is insufficient to give rise to an impersonum claim. So that, yeah, you can, if you see forgery, you can just chuck that sentence on the facts and say this impersonum exception is not available. The second one, probably the more significant, is if the registered proprietor, say the bank who's got the mortgage, has breached their duty of care, say like the bank in, well, okay, first of all, uh, it is not accepted that a bank owes a duty of care to a proprietor of land who's coming in to seek a mortgage. So if you have a fraudulent person coming in and pretending to be somebody, like we saw last week in the fraud cases, it's not entirely settled whether they have a duty of care. But I think Hain in Vassos it'll be, or Pyramid Building Society, one of the two, says even if there was a duty of care, the fact that they had breached that duty of care will not be sufficient to ground an in personam claim. And, I think the example I gave, the last slide, will help you understand why. The in personam claim is about getting, is about, is the general point that the registered proprietor is still subject to causes of action that may get them off the register. Now, if they've had a duty of care and they've breached it by their own conduct, the result of this claim is a damages order. To bring a negligence claim in tort, you need to prove damages. In no way is the remedial order for a breach of duty of care going to do anything to affect a registered proprietor's interest. There's no, almost like there's no forfeiture remedy. It's very separate to their proprietary interest. They'll have to pay money, but again, not related to their position on the title. That's why it's not relevant to the in personam claim ground. Anyway, what is relevant to the in personam claim ground is Bar and Nicolay. Now, don't know if you'll get this on your exam, but on my exam, basically one of the questions was, have you read this case? And not even have you read it, did you watch the lecture? Because it was just 7 marks where you just had to spit out the facts of Bar. It was the exact same thing, but obviously simpler. But so it's a case really worth knowing, and you should read it. There's some interesting points. We studied it last week in the context of fraud. Anyways, the Bars had lot 340 originally. They were broke and they needed to raise capital for a project they wanted to undertake. I don't know what it was. Let's say it was a construction of a mini golf course. They approached Nicolay. I think he was a venture capitalist. I don't know. To raise capital for the project. And how you do that is by selling property to somebody. And then, as happened here, is getting a lease back. So they sold, the Bars had the land, they sold it to Nicolay to get the capital. They received a leasehold agreement back, and that was coupled with a repurchase option and equitable interest. Now, they'd registered the lease, but as we studied in the scope of indefeasibility, that does not protect the repurchase option because they're fundamentally different interests. This case is not so much concerned about the leasehold interest of the Nicolays, of the Bars, sorry. What it's really concerned with is what happens to the repurchase option. So they've got the repurchase option. Nicolet's given that to them. But Nicolet, as the registered proprietor now, has on-sold it to the Thompsons, who acknowledged the interest of the bars in clause 4 of the sale agreement. And acknowledging the interest, that means acknowledging their repurchase option, right? But later, the Thompsons said, "Get lost. I'm not selling you the property." The reason why they did that is because the repurchase option that the bars and Nicolet had covenanted for was for a stipulated price, and prices of property had obviously gone up drastically. Don't know when this case was, but I think it was in the late 80s. So yeah, there's an increase in property prices. So the Thompson said, "Get lost. I'm not selling you the property. I'm going to put it on the open market to get a higher price." So what the bars wanted to do was force the Thompsons to respect their right repurchase option. And as we studied last week, there was no fraud. So they needed a different cause of action and a different exception. So they argued that by acknowledging the interest in the sale agreement between Nicolet and the Thompsons, by acknowledging clause 4, had created a trust in favour of the bars. Why did they make that argument? Well, as I've been saying, indefeasibility does not allow the registered proprietor to avoid the consequences of the cause of action that they've created. So, if a trust was created between the bars and the Thompsons, the bars would be the beneficiaries under the trust, and the Thompsons would be the settlors. The trustees. And the result of that is that the beneficiaries can call the trust capital and force a transfer to them. So that's the cause of action that they're trying to set up. So now we get to the factual matrix and the court's conclusion. I'm trying to go through this case in a bit of detail because it's probably the second most important one, if not the most. Okay, so the court concluded that the Thompsons' acknowledgement created a trust in the bar's favour. All right. Now, it's worth noting that the Thompsons contested this, and they said, "Hang on, we have acknowledged the interest. We have just said that we're aware of it." And if you remember from my topic 5, whatever it is, discussion, topic 6, a couple of weeks ago, that just having a registered proprietor, just having notice of someone else's equitable interest, that being the purchase option of the bars, which is an equitable interest, as I've noted, just having an awareness does nothing to defeat the claim or nothing to taint the interest of a registered proprietor. And that's in section 43 of the TLA. So that's their argument. We've just, by acknowledging it in clause 4, we are just noting that we have notice of the interest, and that would defeat the bar's claim. But the court said, "Hang on, no, your acknowledgement is doing something more." And the reason why they came to that conclusion was the factual matrix, they kept calling it. God, do know this. This is what my exam was based on. The factual matrix was this. Nicolet, in putting the clause in the agreement, clearly intended that the Thompsons were sort of doing something more than acknowledging the interest. They were basically giving an undertaking to respect the bar's rights. The reason for that is because if they didn't, if Nicolet did not ensure the Thompsons respected the bar's rights, Nicolet would have been up for breach of contract, and the bars could have sued him. Because remember, he's covenanted with them at the start that they're going to have the repurchase option. And the only way for him to sell to the Thompsons legally was to ensure that the bars were protected. So, clearly Nicolay's intending that this transaction does something more than merely acknowledging the interests. Okay. Um, and the Thompsons, well, this is a bit of common sense. The Thompsons had already known of the interest before the agreement. So it'd be weird, it'd be a bit weird for them to just jot down in the contract, oh yeah, I'm just making sure that you know I know. So really, it took on something more. It had the quality of a promise, right? So the court concludes in the factual matrix that this is more than an acknowledgement. Now, what do they do with this? Well, two of them say that an express trust is created, that by acknowledging the interest in the clause, the Thompsons had expressly created a trust in favour of the bars, which the bars could enforce. Um, interesting outcome. I'm studying trusts right now. Can't really tell you the merits of that judgment. Yeah, maybe an express trust. Acknowledge the interest isn't exactly explicit language, but in all the circumstances, maybe, and that's what the two justices said. I can't remember their names. No doubt they're luminaries. The other two, though, or three, two or three, so I think it was just two. I think the court was split. Said that it was a common intention constructive trust. That Nicolay and the Thompsons commonly intended to make a trust, commonly intended to give an interest. Give an interest to the bars. That interest being the repurchase option. So it's completely legitimate for two contracting parties to commonly intend to create a trust or give an interest to a third party, that being the bars. So on either view, the in personam claim is going to be made out here, right? So really, in your exam, I'd say to you that if you just canvass the express trust and common intention constructive trust bases, then you'll be okay because it doesn't change the outcome. On the express trust basis, where the bars are the beneficiaries and the Thompsons are the trustees, the bars can force the transfer of the property as beneficiaries of the trust. So yeah, that clearly defeats their registered. That clearly sort of defeats the Thompsons, and the Thompsons can't say, you know, hold on, we're registered, so get lost. So they can't say that, and that's what the in personam exception is trying to do, is prevent them from saying that, and it does so. Um, on the other hand, you have the common intention constructive trust, and it's the exact same. They can force as the beneficiaries under the common intention constructive trust. That's what they are. They're sort of equitable beneficiaries. The bars can force the transfer of property again. So on either view, they're getting the property, and they did. Hooray! But that's just showing you that you have my example from before. This sale of contract. The specific performance, that's your common example. Another common example is where the registered proprietor creates a trust in favor of somebody else. To put bar Nicolay broadly, it'll stand for the proposition that a registered proprietor who creates a trust in someone else, giving them an equitable interest in the property, cannot then turn around and say, I'm not honoring that trust because I'm registered. So that's it. How long did that take? Good Lord. That is a rather long-winded discussion of bar and Nicolay. In your lectures, they deal with it pretty well, I think. I think it's quite a complicated case. So I think it's about, I don't know, was it 32 pages on Westlaw? It's a difficult read, but definitely one worth reading a couple of times and getting your head around. This is the real money maker. This is the in personam case in full, in personam exception in full. This is what you need to read to understand it. And if you get a very good understanding of bar and Nicolay, you can pencil yourself in for It's yeah, 5 or 6 or 7 free marks on the exam, in my opinion. So why not? Um, uh, the Victorian Court of Appeal in Zachary. Uh, Basically, Samir, the father, uh, had created a common intention constructive trust for 50% beneficial ownership in a property in favor of Nagi, uh, his son. I think the property was in Roxburgh Park, prime real estate. Uh, Samir, however, then transferred the property to Marguerite. Um, so there's a common intention between Samir and Nagi. Uh, the father says, "Yes, my son, I will give you 50%." Uh, However, Samir then transfers the property to Marguerite, his wife. Uh, Now, the court accepted this and it was established on the facts that the transfer was only to improve Marguerite's creditworthiness, so she could obtain a loan to get a different property. Uh, Obviously, when you go to the bank, they want to see that you have some assets in case you can't pay back their fees or their mortgage repayments. So this wasn't intended to alter the original arrangement between Samir and Nagi. It was just sort of the periodically or situationally raise Marguerite's creditworthiness. So Marguerite holds the property, uh, and I think she turns around and says to her son, "You're not getting it," which is really nice of her. So you're left with the awful situation where Samir, the son, is attempting to claim his 50% beneficial ownership in the property. Now, Marguerite is the registered proprietor, and Samir has a prior equitable interest. So he needs to establish a cause of action against her to overcome the registration. Uh, so obviously this is where the impersonum comes in. So, if there's a cause of action whereby Marguerite has to transfer Samir the property, the principle of impersonum and will prevent Marguerite from standing on her position as registered proprietor to deny that claim of Samir. Now, rather peculiarly, the court held this trust was enforceable against Marguerite. So Samir's common intention constructive trust that he had created with Nagi's common intention with Samir. Samir could enforce that against Marguerite, as it would be unconscionable for her to deny him his interest, given her subjective knowledge about the limited purpose of Samir's transfer to her. So she knew about the arrangement between Samir and Nagi in a very loose sense, the facts say. She knew that the transfer to her was only for the credit worthiness. It wasn't a gift. So in those circumstances, it was unconscionable for her to deny um, Samir and to deny Nagi, and Nagi could enforce the trust against her, so he could rely on the impersonum claim. Um, this is a lot broader than I think there's a good article. I don't know if it was on the reading guide or I might have read it about how this like sort of radically expanded the approach in Bar and Nicolay. Because in Bar and Nicolay, you had the Thompsons expressly basically committing to upholding or honouring the bar's repurchase option. And here you have Marguerite not doing anything of the sort. She has just got the property. She's sitting there with it, and it would sort of be unconscionable for her to deny his interest. So it seems that there's quite a loose interpretation as to the impersonum exception here. Um, you know, yeah, I found it really hard to wrap my head around this. I think Zachary has been like robustly criticized in a lot of uh, academic journals, not only for this weird, this potential expansion of the Bar and Nicolay approach to impersonum. Uh, but also for this point here, and I'm going to flag it just because it becomes relevant here. Um, Now, Marguerite was a volunteer, so Samir had transferred to her the property. I think it was for the consideration of love and affection, which is basically saying for nothing, rather cynically in the eyes of the law. There was no valuable consideration, so she was a volunteer and she'd registered. So the traditional approach in Victoria is that volunteers do not get into feasibility. So what that means is that even registered volunteers are subject to prior equitable claims against the property. So under the traditional approach, Nagi, without having to go through in personam at all, could have just pressed his claim against the property. And because Marguerite doesn't get into feasibility as a volunteer, traditionally, she'd lose. Um, they wouldn't have to jump. He wouldn't have had to jump through the loop of in personam to get to her and challenge her position on the register. But rather swiftly, the court in Zachary and Zachary threw away. I think it's about 150 years of precedence in a six-word sentence, and cited strange obiter from the High Court, which isn't exactly on point to overturn this and say that volunteers do get into feasibility. So that's the reason why we're even talking about in personam here. So that's good to know, and it might help the volunteer exception sink in later down the line when we get to that. But yeah, very strange case. So it arguably expands the Bar and Nicolay approach to in personam because it introduces this sort of vague notion of unconscionability, which is generally a no-no. And it also rejects a traditional approach that applies to volunteers that they don't get into feasibility. And and they say that they do. They don't expressly say that, but the only reason why they'd be talking about in personam is because they've changed the position on volunteers. So it's a very odd case, and this is one of the ones I don't recommend you read. It's horrible. It's really poorly drafted too. Awful. Uh, okay. Yeah. So speaking of horrible drafting, this is some of my finest work. I'm actually submitting it to the NGV. Um, it's sort of an impressionist take on statutes. Um, but yeah, so if you if you couldn't tell, we're moving on to the Paramount Interest exception, and there's a lot. Uh, so what this is about is circumstances where prior equitable claims will defeat a registered proprietor or will bind a registered proprietor, even though they weren't even aware of it, even though they have indefeasibility. So 2A, so 42 2A, that is that the reservations exception. God, use a comma. The reservations, exceptions, conditions, and powers, if any, yeah, contained in the Crown grant of the land. So when the Palms came marching on down, it was state sanctioned business. So it was all Crown land. Well, not all of it, but the land that the Crown took. It was property of who would have it been? His Majesty. Um, what? King George? I don't know. King George III? That could be wildly wrong. Um, he, yeah, so all the land was vested in the Crown. And what they did was create Crown grants. And every land in, say, I don't know, most of you, all of you will be in suburban Melbourne. Every piece of land can be tracked back to a Crown grant. And for some reason, in that Crown grant, there may be a restriction on the use of the land. So I don't know, say the Crown reserves rights to mine underneath it, should they deem it necessary. Uh, And all this exception is saying that, even if you're registered, that exception or condition or reservation and power on the Crown grant, which you can find on the title search if you like. Yeah, if you want to, uh, yeah, uh, yeah, it binds the registered proprietor despite the principle of indefeasibility. Um, B, any right subsisting under any adverse possession of the land. Um, yeah, so if you have a person adverse possessing you and they stick it out for 15 years, good on them. Yeah, your registration can't defeat their claim, and that's just a public policy basis to avoid the wasteful use or non-productive use of land. Um, cool. Any public rights of way? I think they're mostly talking about like highways and stuff here. So if on your plot, uh, your land is designated as a public highway, but obviously it's not. The council, I think it would be, can come along and say, we're taking this land to be used as a public right of way, a thoroughfare, I think the British call it, freeway. And you can't do anything about that. Your status as registered proprietor and your status as an indefeasible proprietor will not help you. Um, oh, any easements, howsoever required, subsisting over, yeah, easements that have been created against the land. Say you buy the property from John, and John lived there for 10 years. He loved his neighbor Bob, and he allowed Bob to walk over his property to get to work every day, and he granted an easement to do so. Uh, no, if just because you're the new registered proprietor doesn't mean you can sort of escape the obligations of that easement as an express carve out from indefeasibility. Finally, not finally. Oh, this is the interesting one. Okay, we'll leave E to the next slide. F, any unpaid land tax and any unpaid rates and other charges that are charged by the local government authorities or the council. Uh, Basically, this is just ensuring that the council gets their money. Go figure. So, how this practically works is if you're John and you buy a new property uh, and the previous proprietor hasn't paid his water bill for 3 years or has been found guilty of winding back the water dial or the meter, which is a great practice and you should get into it. It's a real money saver. Um, you know, if there's a land tax charge or another bill that is resting against John, the previous owner as proprietor of that land, just because John comes in, buys the property and registers does not mean he avoids that charge. It's an exception in indefeasibility. The charge is levied on the land and the owner of the land has to pay it, even if it wasn't incurred against you while you're the owner. So um, that's an amendment. I think I've seen it come up in one singular practice exam and it was worth 4 marks. No, not even two. It was worth 2 marks. So basically, yeah, any subsisting tax against the land will prevail over you, even if you're a registered proprietor and you get indefeasibility. So um, no dramas there. Section 42(2)(e), by far the most important one, and weirdly, something that you probably won't be able to answer fully until you get to topic 8, but it's worth understanding. We have to, because it comes up in this week of content, but uh, this is setting the backdrop to how you will resolve this dispute. So this exception really arises in the context of a dispute between an equitable tenant in possession and the mortgagor. And there are 3 situations which may come up. I'm sure there's more, but they're not really teaching us much here. So there'll be 3 situations and 3 only. 1, the equitable lease and the possession. So the equitable tenant comes far before the mortgage. In this case, section 42(2)(e) will apply. So that's your most likely scenario because it actually brings into play 42(2)(e). Second, where the mortgage predates the lease, you apply 87C. So if in that case, what that basically says is that if you have a mortgagee, they must consent to any new lease. So if there was no consent provided, the lease, see you later. Finally, with the equitable mortgage, predates the lease, but registration of the mortgage comes after. So this is a weird scenario. Um, really, it probably is just covered by 87C now, but so obviously the mortgages have a contractual component, and when you sign the mortgage, the memorandum of mortgage, you create an equitable interest, an equitable mortgage. So this is talking about a situation where that signing of the contract, creating the equitable mortgage comes before the lease, before the tenant, but the registration comes after the tenant. In this case, you apply Bianco Investments, and that's the same as 87C. As I just went over, you need the mortgagee's consent. So, yeah, cool. Now, how 422E operates if you have that first outcome or first scenario. Again, another confusing majority judgment, I think, but in Perpetual Trustees versus Smith, they provide that 422E is an exception, as an exception, effectively strips the registered mortgagee of the benefit of indivisibility. So they cannot rely on registration to defeat the equitable tenant's right to possession. Now, this does not provide an automatic victory to the equitable tenant in possession. What it does do is it strips the indefeasibility right and basically acts as though the later registered mortgagee is not registered at all and is just an equitable mortgagee. So it creates a de facto priority dispute between two unregistered interests. So the equitable tenant in possession, so the equitable leasehold interest will be going up against the equitable mortgage, even though the mortgage is registered. This is just a sort of legal fiction. Yeah, so you'll learn how to resolve this in topic 8. Hint, if there's an equitable tenant on the land, they're probably going to win, but we'll go over why later. But if you have this sort of situation, the equitable tenant in possession will, I think it's almost certain that they'll win actually, but it's not an automatic victory. There could be other conduct that changes the outcome, as we'll see. But please read the minority judgment here. They love asking policy questions in the past exam about this particular thingo and Perpetual Trustees versus Smith, mostly because yeah, it's strange. I mean, at least the vibes that I got from my lecturer, all the lecturers really from last year, there was I think 3 um, or 4, and the minority judgment in Perpetual Trustees versus Smith, and some of the articles that were available, is that the majority had wrongly decided this. But look, I think you're happy to take the majority as though it is law in Australia. But I think for policy particularly, dive into some of the problems with the majority judgment, and they interpret effectively Section 42(2)(e) as getting rid of the benefit of registration for the mortgagee, which seems to be improper. And if they do that, it's unclear why that applies only to 42(2)(e), but not the rest of the paramount interest in Section 42(2). I can't provide the answers there, but if you want to prepare for a policy question, go read some articles. There'll be a wealth of material on that. Read the minority judgment of Justice What's His Name. It's good from memory. It's a minority judgment, so I don't remember it. So apologies. Yeah, right to rectification. Doesn't really take a rocket scientist to get this one in. You know, if you have an equitable tenant whose interest prevails because of Section 42(2)(e), so they prevail in that unregistered priority dispute, this protection will also extend to their right of rectification. So an incoming landlord is bound to follow agreements between the tenant in possession and the former proprietor. So yeah, so if you have, I don't know, you have the lessee and the old landlord, they agree, oh, hang on, can you pay the mortgage? No, sorry, can you pay the water bills? And, the landlord agrees, yes, I'll pay the water bills, fine. But they don't note it down in their leasehold agreement. and the new landlord comes across, the tenant's right of rectification. Effectively, what it does is it just forces the new landlord to respect that agreement. Oh, now this is really one of the most boring ones. The registrar's power to correct errors. Um, there's a couple of provisions here, section 103, 1A. I think there's a lot of the stuff about like electronic transactions. The law degree stuck in the 1960s. Anytime they bring up electronic stuff, you can disregard it. They don't want you to know it. They want you to know books, only books and paper. It's so old, this course, perhaps, they might even require you to write on papyrus like the Egyptians. But if the court directs the registrar to make any amendments to the register or make any recordings, it shall do so. That's really not saying much. Um, if you've got a claim, uh, fraud, the fraud exception against the bank, and they're struck off the register, and the court orders that, all that's saying is that, if the court makes an order, the registrar has to make the amendments, which would be striking the bank off. Um, so lots of responsibility for the registrar. They might even have to take a big red pen and go, ooh. Um, Section 103, I'd love to, I don't know, if anyone has worked at the registrar of the titles office, please let me know. Like, what happens? Uh, what happens there? Section 103.2a provides that the registrar may, upon such evidence as it appears to be sufficient, correct errors. Interesting. This is expressed as being quite a broad power, but it's effectively been read down. So this is common sense. Courts and not the title office are the only institutions who are competent to determine someone's proprietary entitlements. It's judicial power. So the court in the Privy Council in Fraser and Walker, interpreting an equivalent provision, held that this was a mere slip provision. Effectively, the registrar will only make amendments if it is non-contentious and proprietary rights are not at stake. So, really, it's like a misspelling or something. So, from what I can gather so far, the registrar's power, I don't know much about the titles office, but so from 103.1a, they can take a big red pen and do as they're told and cross something out. And 103.2a provides them power to correct a name, a misspelling of the name. So, truly, uh, the tyrannical power of the registrar is noted. So yeah, look, uh, I've seen this come up once. Paul was the registered proprietor, obviously spelt Paul, and in the exam, the practice exam, I think it was from 2010, it was spelt Pawl. And the registrar did have the power to make that amendment to Paul to spell it correctly. So all was well. Okay. Oh, inconsistent legislation. So, despite its importance, the right of indefeasibility is not constitutional. I mean, obviously, it's a statutory provision. So, subsequent legislation may work an implied repeal of the indefeasibility provisions in certain contexts. We are concerned with implied repeals, not express repeals of the TLA or the relevant sections of the TLA, so sections 42, 43, etc. The reason being is because it's not going to happen. We're fairly content with the whole sort of title by registration scheme we have going on. I don't know, unless one of unless the Victorian government changes it, you never know. General principles. Legislation will only affect an implied repeal of the TLA where they operate in the same sphere. So the two legislations are in the same area, same subject matter, and they cannot possibly stand together. That's from Horvath. And there's a very strong presumption that Parliament did not intend to contradict itself by creating two inconsistent acts, and that the two acts operate in their own sphere. And the courts will read subsequent legislation narrowly where possible to make this happen. Your key cases, and you'll be pleased to know if you hear statutory interpretation and go, no, like most normal people should, in my opinion, really there's these two cases. I think Fraser and Walker is also on the reading guide, but Fraser and Walker is literally just Horvath and Commonwealth Bank, but over in England and with different statutes. Yeah, you're going to have something on your exam, and it's either going to be like Horvath or Calabro. So you have to sit there. Which case is it? Which case do I get to spit out today on the exam? And if you can identify which case you have to literally regurgitate, um, you'll be okay. Although they might trick you. It could be in between the two. Oh, wow. So, Section 49A of the Later Act stated that the mortgages entered into a minor are void and of no effect. The issue was whether this was inconsistent with the TLA, which accorded indefeasibility to registered mortgagees. So basically, did the Section 49, which voided my mortgages entered into by minors, did it sort of affect the indefeasibility of a bank which had registered such a mortgage? So you can see the really limited nature of these sort of questions and disputes. The court read the subsequent act narrowly and held that it was confined only to the contractual sphere of mortgages. So by saying that mortgages entered into by a minor are void and of no effect, and that's what Section 49A of the relevant act said, they're dealing with the contractual sphere of mortgages. So they're saying the actual contract between the bank and the mortgagee, or the bank and the mortgagor, the minor mortgagor, is void. However, the court said that that had nothing to do with the TLA, which provides registered interests upon sort of registering a memorandum. So, you can see how one act was confined to the contractual sphere. You're voiding the actual contract. The TLA is dealing with the effect of registering a voided contract. And there's a long line of authority that if you register a void instrument, you still get indefeasibility. So, you know, basically what the court did in this case was say that it's okay. The Section 49 voids the contract entered into by the minor, but because the mortgage is indefeasible, I think the contract would have been enforceable against him anyway. So, a wonderful piece of statute there. Yeah. So, yeah, one's contractual, one's dealing with registering a document. They don't cross over. So there's no implied repeal of the TLA. So the ultimate outcome is that the mortgage lives on. It's indefeasible still, despite that section. Yeah, so that's cool. Calabro, again, Section 203 of the LGA, Local Government Act, that is, provides the public highways vested in fee simple in the council. And was this inconsistent with the indefeasibility provisions which vest legal title in the registered proprietor? So the issue here is you had obviously someone whose land had public highway marked against the folio. And unlike the Horvath case, you can see the very clear conflict here. One statute, that being Section 203 of the LGA, vests the fee simple in the government, while the effect of the TLA was to vest the fee simple in the owner, the registered proprietor. So they're in the same sphere. They can't stand together. You can't have the council co-owning with you can't have the council co-owning with the registered proprietor. This is not communist China, you know. We don't have state ownership of property. Screw you, Marx. So yeah, in a case of inconsistency, the latter prevails. So yeah, the LGA overrode the TLA in this very specific instance. And yeah, so the TLA is impliedly repealed. If you want to be a super nerd, the court was also guided by some principles of statutory interpretation in reaching this conclusion. First, statutory and public rights will prevail over private rights generally. Don't know about that. I don't know. It seems like a very broad provision or interpretation or presumption, but it's there and they used it. Second, the general does not derogate from the specific. So I've included here the Latin generalia specialibus non derogant. So, you can tell that, if I was born perhaps in the Roman Empire, I would have been Virgil with my brilliant enunciation of the Latin there. But here, the general statute, the TLA, does not derogate from the specific statute. So the LGA, so the LGA is specifically dealing with the fee simple in public highways. The general provision, the TLA, is just dealing with sort of titles generally. So the general one doesn't detract from the specific. So the specific one sort of stands, but these are really just corollary um, presumptions. Now, an important point on the Latin, you have to use it. Yeah, or else you'll fail. Uh, you have to put generalia specialibus non derogant. Um, so yeah, I think if you use the English, you might pass. But yeah, no, no, just kidding. But chuck it in a bracket, I reckon, and let me know if that, I don't know, and request your exam transcript after and see if they've given you a tick. Because I have a funny feeling some of these lecturers do like the Latin, They come from a time back in the day where they may have even studied Latin in school. Heavens forbid. Um, that certainly wasn't offered at my school. But yeah, so no, don't use the Latin. But if you want to, put it in the brackets. I don't know. It looks classy in my opinion. But yeah, I think that's all for this week. Yeah, that's it. How long was that? 50 minutes. That's my quota. Oh, pretty happy about that. Awesome. Apart from that, no, all good. Good luck. Hopefully the semester's going along well. It's going by quickly. Please reach out to me if you have any questions. I think your exam is in good time. You've got a bit of SWAT back. There's not much content left from now. This is a very content weak unit. It just, maybe takes a bit of time to get your head around, but when the time comes, start cracking into those practice exams, and I promise you, you will do very well. So good luck. And next week we'll be doing the volunteers exception, which is interesting. It's a fun one. Not really. Um, oh, the compensation scheme. Yeah. Yeah, we'll see you next week for that riveting stuff. Have a good time.